will come to order. Today, we're going to be considering two measures. The first is a package of bills to strengthen consumer protections and get harassing debt collectors off the backs of American families. We've all seen how the coronavirus pandemic has devastated the livelihoods of Americans from coast to coast. But while people have suffered, debt collectors have made record profits. 1 in 3 Americans are now being pursued by a debt collector today. And abusive debt collector practices like collection lawsuits and wage garnishes disproportionately harm communities of color and low-income communities. The industry makes over 1 billion consumer contacts every year. That's billion with a B. No one is immune, whether it's small business owners, service members, or student loan borrowers. HR 2547 would make a series of reforms to rein in egregious debt collection practices and protect families from this abusive behavior. Second, we will consider a bill to protect pregnant workers from discrimination in the workplace. Congress passed a law outlawing pregnancy discrimination more than 40 years ago. But even today, we see countless examples of employers firing or otherwise discriminating against pregnant workers. When instead of giving a pregnant store clerk access to a stool or water, the employer points to the employee handbook to justify saying, "You're fired." Or when instead of management engaging with a pregnant worker to ensure she is safe and following her doctor's orders, the manager says, "You're fired." No woman should have to hear those words when a simple, reasonable accommodation like a chair or a bottle of water could keep them working and providing for their family. I've been an original co-sponsor of this bill since it was first introduced in 2012. I'm hopeful that now is the time that this bill can not only pass the House, as it did last Congress, but also pass the Senate and be signed into law. It is time to get this done, and I'm now happy to turn to our ranking member for any comments he wishes to make. Tom, you're muted. You got to mute. Okay.
Thank you very much, Mr. Chairman. Appreciate it. Although you may have enjoyed me better muted, but you're very, very kind.
You look very effective.
Better than I sound, I'm sure. Thank you, Mr. Chairman. Today's hearing covers two different items. The first item I will address is H.R. 1065, the Pregnant Workers Fairness Act. Since we considered this bill last Congress, it will be familiar to our returning members. The premise of this bill is one that I think all of my colleagues can get behind. The idea that there should be legal protections in place to protect pregnant women from discrimination. Certainly, pregnant workers should no longer be forced to choose between job security and their health or the health of their unborn child. I understand that today's bill is identical to the version of the bill we considered last year. I was pleased to learn that the bill was the subject of bipartisan negotiations between Chairman Scott and Ranking Member Fox, and that they have reached a bipartisan agreement on all points except one. The lone point of disagreement is over an exemption for religious organizations. I understand that Republicans on the Education and Labor Committee proposed an amendment to add this exemption, and it was unfortunately not accepted. While I'm supportive of this bill, I'm also supportive of adding this religious exemption. And I would urge the committee to grant a rule that allows for a vote on this exemption on the floor. I look forward to hearing testimony on this bill and the exemption specifically during our discussion today. The second bill under consideration is H.R. 2547. That originated in the Financial Services Committee. This legislation is actually a collection of 8 bills that all deal with debt collection practices. As with our first item, I don't think there are any members who would disagree with the fundamental premise that debt collection practices must be fair. Fortunately, the Fair Debt Collection Practices Act is already law and has been since the 1970s. Little in this bill would actually improve debt collection for everyday Americans. In general, the package before us today would fundamentally restructure the consumer credit market and make it much more difficult for businesses, particularly small businesses, to collect legitimate debts and to be paid for services rendered. This would have the unfortunate effect of making credit more expensive for all borrowers and could potentially make credit inaccessible to low-income borrowers. As we consider how best to reform our current credit system, we must be careful to ensure a balance between protecting consumers, ensuring that legitimate debts are paid, and ensuring that credit remains accessible to all. Today's package does include one provision that is both necessary and bipartisan. The package includes the text of the Fair Debt Collection Practices for Service Members Act, a bill that passed the House last Congress by a unanimous vote. This bill would ensure key protections for our service members so that they are not subjected to inappropriate harassment from debt collectors. I hope it will again come to the floor for an independent vote, allowing all members the opportunity to once again make their support known. With that, Mr. Chairman, I yield back.
Thank you very much. Appreciate your opening statement. I'd now like to welcome our witnesses to provide testimony on HR 2547, the Comprehensive Debt Collection Improvement Act. Chairwoman Waters and Subcommittee Ranking Member Buchemeyer, we are delighted that you are here. Without objection, any written materials you submit to rules documents at mail.house.gov before the conclusion of this hearing will be entered into the record. I now recognize the gentlewoman from California, Chairwoman Waters.
Thank you, Chairman McGovern, Ranking Member Cole, and members of the committee for having me here to testify on my bill, HR 2547, the Comprehensive Debt Collection Improvement Act. This package brings together several needed reforms that members of the Financial Services Committee have been developing for years. My committee has had several hearings that have brought to light the unacceptable abuses that consumers continue to be subjected to regarding debt collection. As a committee, we have explored in depth the different aspects of the debt collection industry and its practices during this Congress and in previous Congresses, and it is clear that the problems that existed prior to the pandemic have only worsened during the current crisis. Individuals and families across the country have and continue to struggle with debt, be it medical debt, student loan debt, or other debts, and they're often left with the difficult decisions of deciding which debt they must pay off to survive. These difficult circumstances can quickly turn into a nightmare when consumers are forced to deal with overly aggressive and misleading tactics of some predatory debt collectors. Many consumers have reported to the Consumer Bureau about debt collectors claiming they owe money they really don't owe, abusive language from some debt collectors, and have been wrongly threatened with legal action on existing debts. While there are existing protections afforded to consumers under the Fair Debt Collection Practices Act, or the FDCPA, that law was enacted way back in 1977, and it is time for Congress to enhance and expand the law's protections to better protect borrowers, especially in light of this pandemic. A recent report from the Consumer Financial Protection Bureau reveals that debt collection complaints remain a top issue for consumers, especially in 2020. These complaints frequently describe that the company was attempting to collection on debt that was not even owed by the consumer or being contacted too often. While debt collectors have seen record profits during this time as payment moratoriums and forbearance with respect to mortgages and federal student loan payments eventually conclude, struggling consumers and small business owners will need all the help they can get in addressing payments and debt. HR 2547 includes measures originally sponsored by several of our colleagues. Specifically, Title I of this legislation includes HR 2540, the Small Business Fairness Lending Act, which was introduced by Representative Nydia Velasquez. This provision would prohibit the use of confessions of judgment in lending where a borrower often unwittingly waives their due process rights relating to debt collection, codifying a ban the Federal Trade Commission has had in consumer lending since 1985 and extending it to cover small business owners also. Senators Marco Rubio and Sherrod Brown have introduced similar legislation on a bipartisan basis in the Senate. Title II includes H.R. 1491, the Fair Debt Collection for Service Members Act, which has been introduced by Representative Dean of Pennsylvania. This title prohibits debt collectors from threatening a service member with reducing their rank, having their security clearance revoked, or prosecuting them under the Uniform Code of Military Justice regarding an outstanding debt. The House has passed this title as a standalone bill twice with unanimous support. Title III includes H.R. 2498, the Private Loan Disability Discharge Act, which also introduced by Representative Dean of Pennsylvania. This title requires discharge of privately held student debt in the case of a permanent disability of a private student loan borrower, ensuring they have the same protections federal student borrowers have. The fourth title, H.R. 2537, the Consumer Protection for Medical Debt Collections Act, introduced by Representative Tlaib of Michigan. This title would prevent collection of medical debt for 2 years and prohibit adverse credit reporting on debts relating to medically necessary procedures. If you get sick and need medical care, those circumstances should not hurt your credit score and make it harder for you to get a mortgage or start a small business. Title V includes H.R. 5021, the Ending Debt Collection Harassment Act, introduced by Representative Presley of Massachusetts, which prohibits debt collectors from repeatedly contacting consumers by email or text without their affirmative consent. The next two titles expand FDCPA protections to cover debts owed by federal or state government agencies, including tolls and speeding tickets. Title 6 of this bill, H.R. 2572, the Stop Debt Collection Abuse Act, sponsored by Representative Cleaver of Missouri, extends protections as they relate to debt owed to a federal agency and would limit the fees debt collectors can charge. Title VII of the bill, which is substantially similar to H.R. 2547, the Debt Collection Practices Harmonization Act, sponsored by Representative Meeks of New York, ties statutory damage amounts for violations of the law to inflation and allow for injunctive relief. Finally, Title VIII includes H.R. 2458, the Non-Judicial Foreclosure Debt Collection Verification Act, sponsored by Representative Auchincloss of Massachusetts. This title clarifies that entities in non-judicial state foreclosure proceedings are covered under FDCPA, reversing a recent Supreme Court decision in the recent Obdusky case. I've also filed a manager's amendment which makes technical changes and other clarifications. I would ask that the committee make my amendment in order. Mr. Chairman, it's time to address the long-standing debt collect abuse and reform practices that have plagued our constituents. Given how it helps consumers across the country, it is not surprising that this package is supported by a large coalition of consumer and civil rights organizations, including Americans for Financial Reform, Center for Responsible Lender, Color of Change, the National Consumer Law Center, and Public Citizen. I urge this committee to advance 2547 to the House floor and request an appropriate rule for its consideration. I would like to thank Representatives Velasquez, Meeks, Cleaver, Presley, Dean, Tlaib, and Auchincloss for their contributions to this package and their leadership on these important reforms that will provide relief to many consumers in desperate need of it. I would be happy to answer any questions that you may have. Thank you.
Thank you very much, Chairwoman Waters. I'm now happy to yield to Ranking Member Lukemeyer for any comments he wishes to make. Welcome.
Thank you, Chairman McGovern and Ranking Member Cole, for the opportunity to testify today on H.R. 2547, the Comprehensive Debt Collection Improvement Act. Contrary to the title of this piece of legislation, this bill will not improve debt collection in this country. It will not help those Americans who continue to feel the impact of the pandemic and state and local lockdowns. This bill, if enacted, will undermine our credit markets, hurt small businesses, and ultimately make credit more expensive and less accessible for those who need it most. Every member of Congress can agree that consumers who owe a debt should be treated with respect and dignity. They should not be subjected to abusive or harassing behavior, and they should be able to work out payment options. This premise is already codified in the Fair Debt Collection Practices Act and the Fair Credit Reporting Act. Yet, since taking the majority in the House, Democrats have used their one-party rule to push policies that undermine some of the most fundamental principles of a free market economy in order to cater to the progressive left. There's no better example than the bill that we have before us today. HR 2547 will undermine the financial system by restricting credit reporting and debt collection practices. This is an ongoing trend coming out of the Financial Services Committee majority. Let me be clear. Lenders across the country rely on accurate credit reports to appropriately provide credit to consumers. If this information is incomplete or does not provide an accurate picture of credit worthiness, lenders are forced to raise rates to ensure that they can absorb potential losses. Furthermore, receiving payment for services rendered is a fundamental premise of our economy. Limiting the ability to collect debts will only harm businesses that have provided these services, again, causing them to stop doing business with people with less than excellent credit. Risk management is the foundation in keeping our financial system strong, and smooth functioning credit reporting and ensuring payment for services rendered actually strengthens the credit market, particularly those who need it most. Republicans agree there are reforms to be made to both the FDCPA and the FCRA. During the committee's markup of this bill, Ranking Member McHenry offered an amendment with several common sense ideas to ensure our financial system remains safe and sound while protecting and introducing options for consumers. Unfortunately, this amendment was rejected along party lines. It is worth mentioning that just last month, the entire House voted to support gentlewoman from Pennsylvania, Representative Dean's bill, to ensure the members of our military are not threatened with service-related consequences. There is clearly room to come to bipartisan agreement on these issues. However, this bill will not empower or protect consumers. This bill is a backwards-looking, anti-consumer, and anti-small business solution in search of a problem. Thank you, Mr. Chairman, for the opportunity with you today. I look forward to answering your questions. With that, I yield back.
Thank you very much. And let me, at this time, without objection, I'd like to insert into the record a statement from Representative Craig. And I don't have any questions. I just would say I'm with Chairwoman Waters on this bill, and I strongly support it. I would now like to turn to Mr. Cole for any questions he may have.
Just a few, but thank you very much, Mr. Chairman. Mr. Luetkemeyer, seems to me that, you know, this is an area we could have come to some bipartisan agreement over, and instead you've been sort of confronted with a take it or leave it approach by the majority. So if you would, could you point out some of the areas that we might have been able to work together in this legislation?
Well, thank you for the question, Congressman Cole and Ranking Member. I think, if we just go back to the history of our committee and in working on these things, we have turned around over the last several years with regards to debt collection and credit reporting, things like rental payments, utility payments, using those as something that the credit reporting bureaus can use to put in their algorithms to come up with some credit worthiness of their borrowers. And these are all important things that are there. When you leave out certain things, for instance, they're wanting to limit the medical debt. And while we don't disagree that some of the medical debt needs to be there, the amendment that Ranking Member McHenry offered was one that would actually improve that from the standpoint of helping to, and I think Representative Laudermilk also had one that would improve the ability of the credit folks to be able to look at the credit, look at the medical necessary debt that's incurred, yet not necessarily have to put it into their algorithm. So I think there's a lot of good stuff in here that is there for them to be looking at. Again, the bottom line to all this is that if the credit rating folks do not have enough information or the wrong information, it's going to hurt the very people that Chairwoman Waters and all the folks on her side are trying to help her with this bill, in that it's going to raise the cost. One of the criteria that people look at whenever you're trying to price loans is the risk that you have to take. And if you can't price the loan appropriately, you're going to raise the rate in order to be able to cover your potential losses. If you have the ability to get as much information as possible and ascertain that this is a good individual, that will reduce the loan interest rate and give access to more credit to lots more people. So I really think this is a backwards-looking way of going about this. Again, Chairman, our Ranking Member McHenry had a nice amendment that actually improved several parts of the bill, but it went down on a party line vote. And it seems that we're in a mode here where, regardless of how, the merits of whatever we offer in our committee, it's not gonna be supported. Even though, as we say, one of the bills in here, something was already passed out of committee. So hopefully that answered your question.
It does. Let me ask, I understand during the course of committee hearing, you also or presented a substitute amendment. Not surprisingly, substitute amendments normally go down on party line votes. But were there elements in there that, again, you think would have been more effective, and that perhaps, on reflection, if we could offer them an individual amendment form, there might be ground in some of those proposals to work with the majority?
Yeah, there were several points here that, one of them dealt with the confession of judgment. Another one dealt with the estate of the deceased individuals that were permanently and/or disabled student loan borrowers. They also addressed things, for instance, verification of Social Security numbers to be able to transition away from that. So that's something that's very concerning. We need to try to get away from that because of identity theft. Again, I mentioned earlier, medically necessary debt, non-elective debt. Also, there was a provision in there that dealt with private education loan funds, financial abuse, unlawful mortgage lending, human trafficking, and also directing the GAO to study and report to Congress on the use of non-traditional data, as I said earlier. Some of this is very helpful with regards to credit scoring. So there was, I think, a common sense approach to trying to improve the bill. And it wasn't trying to deep six it at all. It actually was trying to improve the bill and actually make it something that would be worthwhile and workable, and something we on our side could support. And yet it was turned down by majority.
Madam Chair, if I may, I want to ask you essentially the same question. I can certainly understand why you wouldn't accept a substitute amendment for your legislation, but are there elements in the substitute amendment that was offered that you think could be incorporated in the bill, might improve the bills in some way, or give us the ability to find some common ground here?
Well, let me just say that the substitute that was offered by our committee's ranking member, Representative McHenry, was simply a non-starter and not a serious attempt to find common ground on a bipartisan path forward. The McHenry amendment would preserve only a few elements of the bill, H.R. 2547, while weakening many essential protections for the provisions he included. For example, Mr. McHenry included a prohibition on confessions of judgment, similar to Title I of H.R. 2547. However, he included a harmful provision relating to written affidavits, effectively undermining the prohibition on confessions of judgments in the first place. Now, the Federal Trade Commission banned confessions of judgments more than 35 years ago. That was in 1985 for consumer loans. Our committee learned small business owners, like taxicab drivers, have unwittingly waived their typical due process rights when it comes to debt collection because these harmful confessions of judgment terms were tucked into their small business loan. Representative Velasquez has been leading the effort on this in the House, working in a bipartisan fashion with Senators Brown and Rubio. However, if we take the approach proposed by Mr. McHenry, small businesses will continue to simply be ripped off. Moreover, I would add that H.R. 2047 includes several other bipartisan provisions, including Title II, which is based on a bill by Representative Dean to protect service members from harassment and threats from debt collectors. The House has unanimously passed Title II as a standalone bill twice, both last year and this year. Additionally, Title VI would enhance protections related to federal agency debts based on a bill by Representative Cleaver that has been bipartisan for a number of years. But when we tried to move it on the suspension calendar last year, the Republicans changed their mind. Unfortunately, at a time when consumers are suffering while debt collectors make record profits during the pandemic, the House Republican alternative is not a serious effort to reform and modernize our debt collection laws. The bill includes a number of debt collection protections that would help small businesses, service members, students, and other consumers at a time when they need it most. The bill cannot afford to be weakened in the ways this amendment attempts. And so, yes, there was bipartisan agreement on some things, but you know what I think I heard said was that somehow this was a solution that and an answer that was not needed for our consumers. You all know what this pandemic has been about. You know that people have lost their jobs. You know that businesses have closed. You know that the government has had to come to the aid of our constituents with some stimulus support, et cetera, et cetera. And knowing this, this is the most difficult time in the lives of so many Americans. And recognizing that this pandemic was extraordinary in the harm that it caused, all of the debt collectors should be trying to do the kind of workouts instead of harassing that will help people to pay their debts. Most Americans want to pay their bills, feel proud of paying their bills, and would do it if they had the resources to do so. If they had the money, they would do it. But they don't have it. They're trying to work out ways they can do it. Can I reduce my payments to, a small amount each month? What can we do to look to see if any of this can be excused? And nobody is trying to harm the businesses. The businesses are making huge profits. They're doing very well. And so this is a time when I believe all of us as responsible members of government will come to the aid of our constituents and deal with something we never thought we'd had to deal with before, such as this pandemic that has been hurting us all. Thank you, and I yield back.
Thank you very much, Madam Chair. Just one quick follow-up, because again, as I think I stated in my question, I understand why you wouldn't take a whole substitute amendment from the minority. That doesn't happen very often from majorities, and I recognize that. I was just wondering if there were some elements in there that you might find attractive that might be incorporated in floor action. Is there anything at all that you found, might improve the bill in some way?
Identified such, and let me go back and remind you that HR 2547 includes several other bipartisan provisions, including Title II, which is based on a bill by Representative Dean to protect service members from harassments and threats from debt collectors. Of course, that was bipartisan. The House has unanimously passed Title II as a standalone bill twice, both last year and this year. Additionally, Title VI would enhance protections related to federal agency debts based on a bill by Representative Cleaver that has been bipartisan for a number of years. But when we tried to move it on the suspension calendar last year, the Republicans changed their mind. And so, yes, and I think that, the question is answered. Yes, there are some bipartisan bills here, and I'm very pleased and thankful for that. But I think the entire bill should be given not only serious consideration, but support from all of us. This is an unusual time, this pandemic, and we must make allowances for that. Thank you very much, and I yield back.
Thank you, Madam Chair. Mr. Chairman, I yield back as well.
Thank you very much. I want to ask unanimous consent to insert in the record the statement of administration policy in support of this legislation. I now turn to Mrs. Torres.
Thank you, Mr. Chairman. I just want to thank Chairwoman Waters for being such a champion of the working class. And with that, I yield back.
Thank you very much. Dr. Burgess.
Thank you, Mr. Chairman. I'd actually like to ask a question of both of our witnesses on the Title IV of the of the debt collection bill, the medical debt. I think I understand what you're trying to do. I do see some problems with it as it's constructed, and I just wondered what discussion you'd had at the committee level. It strikes me that if you prohibit the collection of all medical debt, the there possibly could be some unintended consequences to that. Yeah, we know consumers and patients have had a hard time during the pandemic, but let's be honest, our docs and our hospitals have as well. And so if we suspend collection of medical debt for 2 years, have you, was there any sort of look at what that might do to the cash flow of, say, a small or medium-sized medical office, what that might do to the cash flow of either a for-profit or a not-for-profit hospital? And I'd actually like both witnesses to answer that if they could.
If you're directing that question to both of us, I believe that 2 years is a reasonable time to get out from under this pandemic. And I do not believe that it would harm the debt, the businesses that are trying to collect this debt. I do believe that not everyone will take advantage of it. Some people will say, I need the 2 years. Others would say, well, I could do it within a year. And others would say, well, I'm expecting some kind of an income where I won't need it very long, maybe for 6 months. But I think that we need to have that kind of flexibility to give our constituents the opportunity to not only have some time to pay off this debt, but to have the flexibility to say, I can do it sooner or I need the 2 years. So I think that it would be a credible way of dealing with that.
And Mr. Lichtenmeyer?
Yeah, thank you, Congressman, for your question. These bills did not go through the subcommittee. I'm the ranking member of the subcommittee. We've never had a hearing on any of these bills. They went through the full committee with a hearing. But your question is a great question. I don't remember it ever being asked about the impact of this. I think most of the discussion that was had was with regards to the impact on the consumer and not necessarily on the provider. And I think your point is well taken from the standpoint that there are actually two entities here that we need to be considering. One is the consumer who is, unfortunately having some medical debt that they're incurring, and the other is the medical professional who is giving this service, and how do they go about collecting enough money to keep their doors open? As we know, it's been a very, very tough time, especially when they were deemed essential workers and were forced to give service. So it's a great question. We had a last session, we had a Representative Lorimer from Georgia had an amendment, but also was defeated along party lines with regards to this medical debt. But again, we're disappointed. I think this is an area where we could come to some common ground on some issues here about how medical debt should be handled. To just exclude it altogether is not fair to the consumer or the provider here, in my judgment. I think it's not reflective of the situation the individual's in, and it certainly is going to be harmful to the provider to be able to provide services down the road. And so I hope that answered your question.
Well, it almost does. We mustn't forget that a year ago, we asked all of our small, medium-sized, even large-sized practices to suspend elective surgeries, elective procedures. And as a consequence, cash flow to medical offices just literally dried up to zero. So bad that we actually had to enact what was called the Provider Relief Fund in the CARES Act that we passed on March 27th of last year. But here is the sort of the enduring problem from that. You have medical practices are in fact small businesses that have been put under significant stress themselves from a cash flow standpoint from the pandemic. And now we are saying that your accounts receivable, rather than being 30 days, 45 days, or 60 days, is in fact going to be 2 years. I can see that it could potentially cause some problems. And I just wondered if anyone had asked the question, taken testimony, or invited public comment from the provider side of the world about what the effect of this would have on being able to maintain a practice. Now, I've got some ideas in this regard, and I really love the opportunity to talk with you and your subcommittee about this, because I do think there's an area here where perhaps we could achieve common ground on some things. Our colleague Ralph Hall, who unfortunately passed away a few years ago, would introduce a bill to try to prevent medical debt from being placed on a person's credit report. I think it's worthwhile asking that question. I know my own experience when I was in practice. I almost never turned a patient's unpaid bill over to a collection agency, and the reason that I didn't is what I found over the years of being in practice, that at some point, although that debt remained unpaid, that patient might have been in a financial situation where they couldn't manage the cash to be able to settle the debt. But at some point in the future, they were going to look at trying to clean up their credit report, perhaps to buy a house or a car, and those bills would eventually be paid. It might be years after the fact, but it could be borne because of the cash flow was there to sustain it. You know, in Texas, back in the late 90s, there was a bill passed by our state legislature that said any insurance company had to remit payment within 45 days, recognizing the stress that insurance companies were placing on medical practices by sort of cutting the check and keeping these debts unpaid, where a doc's office would have to bill and rebill several times before a legitimate charge was ever settled. So I think it's important to look at this in a broader context. I'd love to see us look at something in terms of could we provide some tax relief, some federal tax relief for doctors who provide care that then ends up being never able to be settled because the patient simply can't afford it. Is there a way to subtract some amount of that from the doctor's business taxes? I don't know. I mean, there just seems like there are ways we could go about this that would be fairer to all concerned, and not the draconian measures of just telling a doctor for 2 years you don't expect any payment because you're not going to get it, and you can't. There's no way you can look to be paid. I recognize that not every patient will do that, but it seems to me to be setting a troubling precedent. And I'll tell you what, I'm not a prognosticator, but I would suspect there'd be some significant litigation that could arise from this, because it almost falls into the illegal taking clause of the Constitution. You tell a doc that you're simply not going to be able to be paid for this, and you can't. There's no recourse you have against the person from whom the money is owed. So I'd like the confidence that we've explored this a little more carefully before we pass this. I understand the intentions, and I understand the difficulties that the pandemic has created for people. I just think there was a way to look at this in a way that was a little more expansive and perhaps a little fairer for all concerned.
Yeah.
And thank you, Mr. Chairman, for allowing me to vent, and I will yield back.
If the gentleman is yielding, I think I just heard you describe illegal takings in a way that the law really does not determine. This is not an illegal taking. Nobody's taking anything from anybody. What we're saying is that there will be some time given to pay off the debt. That is not illegal takings at all. And so we're not saying people don't have to pay their debt, but we're asking for a little time for them to do it, and we're giving them some options. And as I said before, this bill is intended to limit collection and negative credit reporting in limited circumstances. It does not limit the obligations owed to hospitals. It does not prevent hospitals or medical providers from collecting on this debt should they choose to use a route not involving debt collectors as defined by the FDCPA. HR 2547 makes it unfair practice under FDCPA for debt collectors to collect medical debt owed for a period of time after the first payment is due. Now, you said that we had been of assistance to providers in, what was it, the CARES Act? Or was that in the CARES Act? So we did help out providers in the way that we tried to help consumers. And so both consumers and providers have been assisted, a combination of, or at least in the CARES Act, and it may have been something in the American Relief Plan also. So they were not left without consideration. Is that right?
Well, will the gentleman yield back, or rather reclaim my time?
Well, I would like to have a colloquy with you on this issue. Number one, I would like to ask you if, in fact, what you just alluded to, you didn't describe it in detail, and maybe you could help us with that because I did not remember that. How did we help the providers? Did we have a certain amount of money that we allocated for them? Do you remember how that was done?
Yes, I do. I remember it very well. The process was awful. Mr. McGovern will remember we sat in the Rules Committee on, I think it was March 13th of 2020, with the pandemic just literally in the windshield staring us in the face, and we had to come up with some answers pretty quickly. And one of those answers was a bill we passed in the middle of March, and then we came back and passed a much more expansive bill at the end of March. But, and I don't want to sound like a whiny authorizer here because I recognize my ranking member is an appropriator, but we didn't authorize any of this money. $100 million went to the Department of Health and Human Services, and it was administered by the Assistant Secretary of Health. I think it was Secretary Hargan, if I recall correctly. And that money was to be doled out to hospitals, doctors, and medical providers writ broadly in order to help them with the pandemic. But we did not put any parameters into that. We did not have any hearings on the Committee of Energy and Commerce. We did not ask what would be necessary, what would be required. We just simply shoved money out the door, and then we added some additional money to that in the middle of April. A good thing. I'm not arguing that that was done with any ill intent, but I think if you were to then question some of the people who were charged with taking care of some of our sickest patients during that time, both doctors and hospitals, you would find that there is a great deal of dissatisfaction with how the how that money actually came downstream. And essentially, the large hospitals were able to petition the agency rather effectively, which of course you might imagine that would be one of the problems that would happen. But a small provider, a doctor's office, would have a great deal of difficulty in being able to make their voice heard at the other end of the bureaucratic chain. So all I'm saying is I think there was an opportunity here to look at this in a little bit more fulsome manner. And it's really unfortunate that we didn't, because here was an opportunity to help patients, help doctors, help hospitals, all of whom we all acknowledge have had a very tough time due to the pandemic. But just the normal practice of medicine is not easy. It is hard. The cash flow from month to month, it can be dicey. When I ran my medical office, every bill was paid, every employee was paid, every charge was paid before I took a paycheck. And that's what we've asked our doctors to do for these last 14 or 15 months, and it's been tough on them. I hear it all the time. But again, I'm prepared to yield back. I just wanted it known that there's an opportunity here. We could have looked at this in a more fulsome way, and I regret that we didn't. But I'll stand ready to help the members of the Financial Services Committee to the extent that I'm able. Perhaps we could work on something in the future. And with that, I'll yield back.
If I may, in this colloquy that we're having, we did have a hearing by the subcommittee in March. So let us clear that up. Secondly, I'm so pleased that you cleared up that we did help the providers, the hospitals, and the doctors, because when we started out this conversation, it seemed as if they were left holding the bag.
Reclaiming my time, and this is an important point. All sectors of our healthcare system came under stress this past 14 months due to the pandemic. And we are now talking about doctors' offices. I'm talking about small practices, onesies, twosies, perhaps 3 or 4 partners who have suspended their own pay in order to keep their practices going, which is what we asked them to do. They may have gotten help to pay the rent, may have gotten help to pay the help, but they didn't get help to pay themselves. That's not the way a small business works. you get your paycheck after every other debt has been settled. So I worry that we've unevened the playing field here. I think we had an opportunity. And Mr. Lichtenmeyer, you were shaking your head no when about the hearing part. Look, if you have a hearing, I'll be happy to come and talk with you. And unlike the Rules Committee, there'll be a clock on me, so I won't be able to go on forever. But these are important points, and I do think we're the Congress. We should want to get this right. And that's the last I'll say about it.
Will the gentleman
I'd be happy to
yield?
yield.
I think, okay.
Well, let me just say that one of the things we have learned here in this we did help the providers. We did help the hospitals. Now, you say it's not enough. They may not be happy. But of course, if you ask many of our constituents, would they like to have had more? More of the consumers would the consumers, many of our consumers say, I didn't think the $1,400 was enough. I need more. And so it's not about whether or not vote. And we did not ask the medical profession to not be paid. We said, could you be a little bit more considerate? And in this time of this pandemic, can you allow those with medical debt to take a little bit longer time? They don't have to take that longer time. They can pay off sooner if they want to. But please, let's know. We did have a hearing. Let's clear that up. And let's also thank you for sharing the information that the providers and the hospitals also got helped by all of us in this time of need. Thank you, and I yield back.
Thank you very much. And even though we don't have a time limit in the Rules Committee, I would just remind everybody that we have to get through this bill and we have another bill to come. And then let me just, whoever had the barking dog, thank you for feeding him because he's no longer barking. So I want to yield now to Mr. Perlmutter.
Thanks, Mr. Chair, and to my chairwoman and to my ranking member. Good to see both of you. And I would remind my ranking member, we did have a hearing on debt collections. We called it that the title of our hearing was Slipping Through the Cracks, Policy Options to Help Consumers During the Pandemic. And these bills were under consideration during our committee hearing. But I appreciate the gentleman's points. I mean, much of what we have in front of us has been agreed to over time. And I appreciate Mr. Burgess's comments. I mean, Ralph Hall brought we're not going to allow medical debt to be part of credit reporting. He brought that for years. And rightfully so. And I appreciate what Dr. Burgess said about his practice of allowing his patients time to pay their bills. Most doctors do that. Almost all doctors do that. Maybe it's part of the Hippocratic Oath. I don't know, but they do that. So and then I appreciate you bringing up the point that we did provide for the medical providers, for the hospitals, in the CARES Act, in the ongoing CARES Act, and in the American Rescue Plan, there's money for the medical profession. So, we're trying to take into consideration this pandemic and the effect that it's had on individuals. And we understand that the consumers had problems, whoever's providing it, whether it's the doctor or a landlord or whoever else, we're trying to help up and down the scale. Not perfectly, but we're trying to help. And so to the ranking member, Mr. Cole, to you, Dr. Burgess, I would just say, and I'll get a chance to argue with this since I'm carrying the rule tomorrow, much of this is bipartisan. Much of this has been agreed to over a long period of time. And even the points that you've raised about the medical debt, much of that's been agreed to. There is no taking here. Okay, the only delay is to give the consumer a notice of their Bill of Rights, of their rights to contest the particular debt. But then it's just, let's give everybody some time, which doctors do ordinarily in their practice. Now, your point may be, well, we don't want to be forced to, and I appreciate that. But Mr. Chair, I've got plenty of time to talk about this bill tomorrow, and I'll yield back.
Thank you very much. Mr. Rushenthaler.
Thank you, Mr. Chairman. I appreciate it. And I would just have to say to Chairwoman Waters, I think your dogs might be Republican. I don't know. You might want to check on that because they were going nuts during your argument. But with that, for the sake of time, I'm gonna yield back. And thanks, Mr. Chairman. I appreciate it.
Thank you very much. We're now going to Mr. Raskin. And Ms. Scanlon. See Ms. Scanlon. Mr. Morelli.
Actually, appreciate the work being done by the sponsor of these bills, and I have no questions. Mr. Chair, I'll yield back.
Okay, thank you. Ms. Fishbach.
Thank you, Mr. Chair. I just have a really I really appreciate the questions of Ranking Member Cole and of Dr. Burgess, but I just wanted to ask Representative Hookenmeyer, could you just maybe expand a little bit on some of the broader effects? I know that there was some discussion about the effects on the credit market, but maybe expand on that and give us some sense of the effects on the cost of credit and some of the unintended consequences of the bill.
Yeah, the bills all go in different directions here. I think one of them, for instance, is the one with regards to student loan debt and disability, or people who are disabled. What they're doing is codifying existing practice there. So I think there's another bill in here that deals with veterans. Debt collection, which is one we've already agreed to. So, but obviously the ones of concern right now are the ones that we're talking about with regards to medical debt collection. Again, there was an amendment that in past years was there that actually would narrow the focus of this a little bit. With regards to Ms. Presley's Ending Debt Collection Harassment Act. The CFPB in October of 2020 finalized a rule to modernize debt collection practices. The final rule clarifies how debt collectors may use modern communication technologies such as text message and emails consistent with the e-Sign Act and National Commerce Act. And so, again, we're trying to, I think, we're trying to eliminate some of the things, some of the protections that have been put in place there. And actually, if you look at what's actually being done in the debt collection area, right now, the debt collection companies, because of the pandemic, have been very, very willing to work with people. They're sitting becoming financial advisors from the standpoint that they want to try and help people work out of this debt situation they're in. They've been very, very lenient and compliant with regards to helping individuals with their credit scores through all this. And I think, the last bill I think here was the Harmonization Act by Mr. Meeks. Again, it actually is something that bans the government's ability to contract with third-party debt collectors. So I think there's some of these bills are things that we could find common ground with, but some of them I think are they're throwing speed bumps in the way of people being able to have good credit scores. The consequences of a bad credit score, or you're not able to get access to credit, or the interest rate on your loan, whatever it may be, goes up. And anybody who's tried to finance a car knows that this is what happens. If you can go in and they can say, well, the rate will be this. They find out your credit score is lousy, then the rate goes up. If you got a good credit score, the rate may go down. So the credit score is very, very, it causes the rates to be very, very sensitive to it. And again, whenever you don't have all the information in front of you, it really hurts the ability of the creditor to be able to figure out whether the individual is creditworthy to a certain point to allow a certain rate. And interest rates are reflective of risk. And if the greater the risk, the higher the rate. I mean, it's pretty simple. So again, if you look at the numbers with regards to those folks who struggle getting access to credit here, it's a very, 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 very small minority of folks. And there's a lot of help out there with regards to financial advice, financial literacy stuff that's available to folks to be able to access that to improve their credit scores. And I think, as I said earlier in my initial comment, I think to Mr. Cole, there was a lot of, over the last several years, I've been on the committee for quite a few years, there's been an opportunity, and we've gone along with, and I think rightly so, improving the ability with these algorithms that they now use to put more things into that, rent payments, utility payments, and other insurance payments that show that an individual is responsible, that they do take care of their debts. And the medical debt is something that's kind of an outlier from the standpoint that if somebody's got an illness, it really devastates their entire financial picture. Now, if you look at their prior to this and probably subsequent to that, your creditor will a lot of times, see that on a credit report, but just sort of, okay, are you able to make the rest of your payments? And if they are, they move on. So I think there's a reason for it for concern there, but I think that the reality of how things actually work out is a little bit different than what we're talking about here. But I hope I answered your question.
Yes,
thank you.
Thank you very much. I appreciate it. And Mr. Chair, that's all I have. I'll yield back.
Thank you. And I think I want to state for the record that I see it was Dr. Burgess who had the barking dog. So, Mr. Reschenthaler.
I was going to say they must be Democrats.
No, I think that the dog was not happy with Dr. Burgess's question. I just want to.
If the gentleman will yield, his girlfriend had gone to the vet.
Okay.
And it upset him. And I've calmed him down now, so I apologize.
All right, that's okay. But I thought the record should reflect that. Mr. DeSaulnier.
Now, the hearing's clearly gone to the dogs, Mr. Chairman.
Does that mean you yield back?
Yes, I yield back. I'm
Okay.
sorry.
All right, Ms. Ross.
Thank you, Mr. Chairman. I will be brief. I just wanted to point out that in addition to all the other important consumer protection measures in this bill, that frequently these debt collectors threaten our service people, our small business owners. They harass consumers and homeowners with repeated calls, texts, and emails. And that makes it very difficult for people. Sometimes they're contacted in their workplace. And what I wanted to say is thank you to the chairwoman for allowing me to include an amendment to the bill that directs the GAO to investigate communications by debt collectors and provide specific recommendations to reduce harassment and the abuse of individuals with debt. People are in a difficult situation to begin with, and the additional stress of these repeated calls, emails, texts, and even potential compromise of their privacy makes the situation only worse. And thank you very much to the chairwoman for bringing this forward, and with that, I yield back.
All right, does any other member of the committee wish to ask a question? Seeing none, I'd like to thank our witnesses for your testimony, and you are now excused. Are there any other members who wish to testify on HR 2547? Hearing none, this closes the hearing on HR 2547. I would now like to call up the next panel to testify on HR 1065, the Pregnant Workers Fairness Act. Chairman Scott and Ranking Member Fox, we're delighted that you are with us. Without objection, any written materials you submit to rules documents at mail.house.gov before the conclusion of this hearing will be entered into the record. I now recognize the gentleman from Virginia, Chairman Scott.
Thank you, Mr. Chairman. Can you hear me?
Yes, I can.
Good, thank you. Thank you, Mr. Chairman and Ranking Member Cole. I'm pleased to speak today on HR 1065, the Pregnant Workers Fairness Act, a bill that has been championed by Congressman Nadler for many years. No one should have to choose between financial security and a healthy pregnancy. Yet in 2021, federal law still does not clearly guarantee all pregnant workers the right to reasonable workplace accommodations. These accommodations, from providing seating and water to excusing pregnant workers from tasks involving dangerous substances, are not complex or costly. However, without these basic protections, too many workers are forced to either leave their jobs or put their health and the health of their pregnancy at risk. In 2015, the Supreme Court allowed pregnant workers to bring claims for reasonable accommodation under the Pregnancy Discrimination Act, in the landmark case of Young versus UPS. However, that decision set an unreasonably high standard for proving pregnancy discrimination. Under the Young standard, workers must prove that the accommodations they were denied were provided to other workers who were, and I quote, similar in their ability or inability to work. This standard is onerous in part because it assumes that workers can access their coworkers' personal health information and establish comparable groups of workers. It also creates a perverse legal framework in which companies that treat all of their workers poorly can treat pregnant workers equally poorly. Since the Young decision, courts have ruled against pregnant workers seeking accommodations in approximately 2/3 of the cases. Without federal action, nearly 36 states and localities have filled the void by establishing their own protections for pregnant workers. This patchwork approach not only frequently leaves workers without clear protections, it also forces multi-state employers to comply with different workplace standards. The Pregnancy Workers Fairness Act is a bipartisan bill that would finally establish the principle that all pregnant workers have the right to reasonable accommodations, and it would guarantee that pregnant workers can seek those accommodations without facing discrimination or retaliation. Employers already have had several decades of experience providing reasonable accommodations under the Americans with Disabilities Act. This is why, in addition to labor unions and civil rights groups, businesses across the country have also endorsed the bill. Last Congress, the Pregnant Workers Fairness Act passed the House with overwhelming bipartisan support. Every Democrat and a majority of Republicans joined in a 239-73 vote in final passage. I hope we can come together again this year and finally get this basic protection for pregnant workers to the President's desk. Thank you, Mr. Chairman, and I yield back.
Thank you very much, Ranking Member Fox.
Thank you very much, Mr. Chairman. Education and Labor Committee Republicans have long been committed to policies that empower all Americans to achieve success. Discrimination of any type should not be tolerated, and no one should ever be denied an opportunity because of unlawful discrimination. That is why there are important protections under federal law to prevent workplace discrimination, such as federal laws that protect pregnant workers, including the Pregnancy Discrimination Act, PDA, and the Americans with Disabilities Act, ADA. These federal laws ensure workers are not being discriminated against and that they receive reasonable accommodations related to pregnancy, childbirth, or related medical conditions. However, supporters of H.R. 1065, the Pregnant Workers Fairness Act, PWFA, argue that there are cases in which courts have not interpreted the PDA or the ADA as covering certain pregnant workers in need of reasonable accommodations. Since its introduction in the 116th Congress, the Pregnant Workers Fairness Act has seen significant improvements as a result of bipartisan negotiations involving the committee and outside stakeholders. The bill that passed the House in 2020 included those improvements, as does H.R. 1065. I give credit where credit is due and commend Chairman Scott for his outreach in this regard. I will briefly summarize these improvements. As previously introduced in the 116th Congress, this bill did not require a pregnant worker to be eligible for an accommodation to be able to perform the essential functions of the job with a reasonable accommodation. This requirement is a sensible provision now included in H.R. 1065 with additional language that a temporary limitation which prevents performance of an essential function may qualify for a reasonable accommodation. Further, a definition of known limitations related to pregnancy, childbirth, or related medical conditions was also initially excluded from the bill as introduced in the 116th Congress. but HR 1065 includes such a definition and a requirement that employees communicate the known limitation to the employer. This provision will help workers and their employers understand their rights and responsibilities. Additionally, the bill as introduced in the 116th Congress appeared to allow employees a unilateral veto over offered accommodations. But HR 1065 clarifies that reasonable accommodations will typically be determined through a balanced and interactive dialogue between workers and employers, similar to the process implemented under the ADA. HR 1065 also includes an improvement from the bill introduced in the 116th Congress, ensuring that if an employer makes a good faith effort to determine a reasonable accommodation through the interactive process with the employee, the employer is not liable for damages. Finally, HR 1065 does not apply to employers with fewer than 15 employees, the same employee threshold in the PDA and the ADA. Unfortunately, despite agreement on these improvements, one major issue remains to be addressed: providing important current law protections to religious organizations. This current law provision protects religious organizations from being forced to make employment decisions that conflict with their faith. Without this provision, HR 1065 could result in religious organizations being denied protections they receive under current law. During the committee markup of this bill in March, Republicans offered an amendment to include this narrow but long-standing provision from the Civil Rights Act that is not currently incorporated in the bill. Regrettably, committee Democrats defeated this amendment. To ensure that all House members have an opportunity to vote on this common sense modification, I have submitted this amendment to the Rules Committee, and I ask that it be made in order under the rule for this bill. The First Amendment guarantees of all Americans. Start all over. The First Amendment guarantees all Americans the freedom of religion. And for over 240 years, Supreme Court decisions and laws written by Congress have maintained strong protections for religious liberty. Not including such a provision in this bill will lead to confusion and legal jeopardy for religious organizations. While we've made good progress negotiating on the Pregnant Workers Fairness Act, the omission of the Civil Rights Act protection will result in this bill dealing an unnecessary blow to religious liberty. Thank you, Mr. Chairman and Ranking Member Cole, and I yield back.
Well, thank you very much. I want to insert in the record a statement of the administration policy in support of this. And I've looked at all the endorsements of this bill from all these different organizations, including many religious organizations and faith-based organizations, and I think the ADA has dealt with the issue that Dr. Fox has talked about. I think the only reason to kind of bring this up is to try to inject a little bit of partisanship in this debate, which I hope that doesn't exist, because again, last time it was up, an overwhelming majority of Republicans voted for it. So I support the bill. I hope it passes by a bigger margin. And with that, I yield to the ranking member.
Thank you very much, Mr. Chairman. I'm going to take mild exception to your concern about injecting partisanship. I first want to congratulate both Chairman Scott and Ranking Member Fox. I think it's a very good piece of legislation. I voted for it the last time it was there. Certainly look forward to voting for it again. I do think Ms. Fox makes a good point on the religious exemption. That's pretty standard in a lot of these things. I wish we had it. I hope we do. I want to offer a chance if she wants to elaborate at all on that particular point. And if we had it, I think it would pass unanimously. And I say there's somebody, by the way, is going to vote for it regardless of whether or not that's included. But I'd vote for it a lot more enthusiastically with that measure there. And I think some people that might vote against it would be persuaded to vote for it with that single, relatively minor addition. Ms. Fox, would you care to add anything to your argument?
I think you're going to have to unmute, Dr.
Got it. I want to thank you, Ranking Member, for the comment and question. I do want to reiterate what I said. Chairman Scott and I worked very hard to get along well and to bring forth bipartisan legislation, and we have done that. And I do think it's unfortunate. I think the Ranking Member is correct. I think this bill would probably receive near unanimous support if we had corrected this little piece, which I think ultimately is going to present court challenges. And I think it's unnecessary to do that. Almost everything else that we've done, which involves a civil right, we bring in the civil rights legislation. And so I think it's unfortunate. So I agree with you. I think it would have been better. No bill's perfect, but it would take it a lot closer to that. So thank you for that comment.
Thank you very much. With that, Mr. Chairman, I'll yield back.
Thanks. And again, I'm just having a tough time here trying to figure out what religion would object to, making sure or object to demanding that an employer not discriminate against somebody and deny them the basic accommodations like a bathroom break or access to water. I don't quite understand, even though as I said before, we have a lot of laws that make this religious exception unequivocal, but on this, I don't really get it, but that's me. I'm happy now to yield Mrs. Torres. I don't see her, so I'm going to go to Mr. Perlmutter.
Thanks, Mr. Chair. I thank the witnesses for appearing, and I don't have any questions.
Dr. Burgess.
Yeah, thanks to our witnesses, and I'll yield back.
Thank you. Mr. Rushenthaler.
Thank you, Mr. Chairman, and I too would yield back.
Okay, Mr. Raskin.
Thank you, Mr. Chairman. I'm delighted to support HR 1065. It's a big moment when we can overcome some of the tone deafness of the Supreme Court and establish the principle that pregnant women at work have a right to reasonable accommodation to their pregnancy. But I also confess to being a little bit baffled by the amendment, which would provide for a religious exemption from having to establish a reasonable accommodation for pregnancy. I'm with the chairman. I can't, I'm racking my brains and trying to hypothesize a religion that would have some reasonable theological basis for discriminating against pregnant women and stopping them from having full access to employment in the workplace or in commerce. And I don't know whether, maybe I can ask Ms. Fox and the chairman of the committee whether there was any discussion of churches that wanted to be able to discriminate against pregnant women in terms of making a reasonable accommodation.
I'll defer to the chairman, and then if
You got to unmute, Chairman Scott.
Thank you. This doesn't change the law in terms of the Establishment Clause, the Free Exercise Clause, or the Religious Freedom Restoration Act. It doesn't change any of those laws. When you say you can't imagine one, we're trying to find a case where a religious exemption was actually sought, and there's one review of 1,000 Title VII religious exemption cases, and not a single one involved an employer objecting to providing pregnancy accommodations. And the question, as the chair just mentioned, what are we talking about? What religion would say you shouldn't allow a extra bathroom breaks for someone that's pregnant, or access to more water, opportunity to sit and rather than stand? What kind of religion would would provoke those kinds of things. And there's another, just kind of practical issue, and that is that 230 organizations have endorsed this bill. They've endorsed this bill. Once you start tinkering with it, some organizations, some of the 230, will lose their enthusiasm and withdraw their support. It's a very, when you get organizations from labor, women's groups, business, civil rights, all kinds of different groups agreeing to a bill, it's, you are at your peril if you try to change any of it, because then you've got to go back and check to see if people are going to withdraw their endorsement. And if this amendment is agreed to, I can assure you that many organizations will withdraw their endorsement.
You know, but Mr. Chairman, I was trying to remember, I had taken a religion course once, a comparative religion class, and I remembered that the Shakers were a completely abstinent faith. And I can imagine if you had a Shaker employer, perhaps they would reject a reasonable accommodation for a pregnant woman out of some kind of theological conviction. But I think that the Shakers, because they didn't believe in reproduction, I think that they're completely gone. I think that they have vanished as a religious faith. So I don't know that there are any churches that would have any standing to complain about this. So I yield back to you, Mr. Chairman. Thank you much.
Ms. Fishbach.
Mr. Chair, I have no questions. I'll yield back.
Okay. I think Ms. Torres wanted to be recognized.
I have no questions, Mr. Chairman, other than to thank Chairman Bobby Scott for coming to our committee again on behalf of pregnant working moms. Really appreciate your work on this, and I yield back.
Thank you very much. Ms. Scanlon.
Yes, I just wanted to thank Chairman Scott and the ranking member for their work in bringing this bill to the floor again, and appreciate the opportunity to also learn more about the Shakers. So thank you. I yield back.
Thank you. Mr. Morelli. No? Okay, Mr. Morelli, going once, twice. Okay. Mr. DeSagne.
No questions, Mr. Chairman. I yield back.
Ms. Ross.
Thank you, Mr. Chairman. I too I'm in full support of this bill. I've done work on the rights of pregnant workers and the rights of pregnant students, and maybe we can have a bill on that later because we've still got problems with that. But it's a great bill, and I yield back.
Thank you very much. Does any other member of the committee wish to ask a question? Seeing none, I want to thank our witnesses for their testimony. You are now excused.
Thank you, Mr. Chairman, and thanks to the members.
Thank you. Are there any other members who wish to testify in HR 1065? Seeing none, that closes the hearing portion of our meeting. At this time, the chair will entertain a motion from the distinguished gentleman from Colorado, Mr. Perlmutter.
Thanks, Mr. Chair. I move the committee grant HR 2547, the Comprehensive Debt Collection Improvement Act, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services or their designees. The rule waives all points of order against consideration of the bill. The rule provides that the amendment, in the nature of a substitute recommended by the Committee on Financial Services, now printed in the bill, modified by the amendment printed in Part A of the Rules Committee report, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides that following debate, each further amendment printed in Part B of the Rules Committee report, not earlier considered as part of the amendments en bloc pursuant to Section 3, shall be considered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, may be withdrawn by the proponent at any time before the question is put thereon, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule provides that at any time after debate, the chair of the Committee on Financial Services or her designee may offer amendments en bloc consisting of further amendments printed in Part B of the Rules Committee report not earlier disposed of. Amendments en bloc shall be considered as read, shall be debatable for 20 minutes, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services or their designees. Shall not be subject to amendment and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part B of the Rules Committee report or amendments en bloc described in Section 3 of the resolution. The rule provides one motion to recommit. The rule further provides for consideration of H.R. 1065, the Pregnant Workers Fairness Act, under a closed rule. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Education and Labor or their designees. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Education and Labor, now printed in the bill, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended, and the rule provides for one motion to recommit. The rule provides that at any time through the legislative day of Friday, May 14, 2021, the Speaker may entertain motions offered by the Majority Leader or a designee that the House suspend the rules with respect to multiple measures that were the object of motions to suspend the rules on the legislative days of May 11th or May 12th, 2021, and on which the yeas and nays were ordered and further proceedings postponed. The chair shall put the question on any motion without debate or intervening motion, and the ordering of the yeas and nays on postponed motions to suspend the rules with respect to such measures is vacated. Finally, the rule provides that House Resolution 379 is hereby adopted.
You heard the motion from the gentleman from Colorado. Is there any amendment or discussion? Mr. Cole.
Thank you very much, Mr. Chairman. I have an amendment to the rule. I move that the committee add language to the resolution that would eliminate the tolling of days for resolutions of inquiry. Mr. Chairman, I know that we continue to discuss the issue of resolutions of inquiry on what seems to be a weekly basis. The Speaker and the Democratic majority have ruled with an iron fist, beginning in earnest at the start of the 117th Congress. In one fell swoop, they eliminated two critical minority tools, the motion to recommit and the use on resolutions of inquiries. To be fair, we appreciate the fact that you didn't actually eliminate resolutions of inquiry. You've actually simply delayed them, but they've been delayed for 127 days. The last time I offered this motion, Mr. Chairman, you stated you would talk to your leadership about this issue. But one of the issues you were hearing about were the number of extra votes and, in your words, unnecessary votes that we were casting. I can certainly appreciate Chairman's position on that, and in some cases we agree. But respectfully, resolutions of inquiry, if considered in committee, would have positively no impact on the floor schedule. Committees are open and operating. During committee work week in March, committees held 50 hearings and 4 markups. In the last 2 weeks, committees held a combined 84 hearings and marked up 37 separate pieces of legislation. So committees can and certainly are doing their work. So it just seems to us, Mr. Chairman, that we ought to go back to our normal procedure and allow for these particular motions of inquiry. With that, I would urge adoption of my motion and yield back.
I thank the gentleman for his amendment. I would say we are still I'm still having conversations with our leadership. It's a long conversation, and but I just want to, and again, I get the gentleman's point, but understand that while we're now trying to respond to the multiple votes on suspensions, that unfortunately those disruptions occurred on a regular basis and disrupted a lot of committee meetings and actually put everything way behind. And and I think some chairs are trying to play catch up. But I understand the gentleman's point, and I will continue to raise it. He's right, it's mostly a committee uh, issue more than a floor issue, and I will get back to the gentleman, but at this particular point, I would urge a no vote.
Mr. Chairman, Burgess here.
Yeah.
This is such an important issue that our ranking member brings up, and honestly, it becomes an issue in committee, but it's an important tool for the minority to use while in committee. Your colleague from your state delegation, Mr. Kennedy, used the motion, resolution of inquiry quite aggressively in the Health Subcommittee 2 Congresses ago. We accommodated him every time he would bring one of these to the committee, and I find it's unnecessarily restrictive that I cannot use these same tools now that we're in the minority and to answer some very important questions. As you know, there's been a complete change of personnel over Department of Health and Human Services. They are slow to answer phone calls. They are slow to get back to you. Perhaps if we had the ability to put forward a resolution of inquiry in committee, maybe it would generate a little bit more responsiveness on their part. So I urge you to continue and conclude that long conversation, because it's an important tool you're denying the minority.
Yeah, well, I can't answer for the delay in responses from the Department of Health and Human Services. Perhaps if there was a transition, we wouldn't have this problem. But as you know, the previous administration decided not to have a transition, and again, push a big lie that they continue to push. But putting that aside, when Congressman Kennedy made those inquiries, we were in the middle of a pandemic, and we weren't occupied almost, ever on the House floor dealing with suspension votes. So I will continue the conversation. I get the gentleman's point, but at this particular point, I would urge a no vote. Mr. Rushenthaler.
Mr. Chairman. Thanks, Mr. Chairman. I appreciate it. Yeah, I'm also on the Appropriations Committee. I know that there are issues on the floor, but the committees are still functioning. So, great example, we had a Energy and Water Subcommittee meeting. Secretary of DOE spoke. In a few weeks, we're going to have Secretary Blinken speaking. So the committees are up and running, and I think for that reason, we should bring back the resolution of inquiries as well, just because aside from the floor, we do have the committees up and running pretty well. And with that, I yield. So I support the ranking member's motion. With that, I yield back.
And I would just say with respect that that's a recent phenomenon in the sense that many committees were totally derailed as a result of the constant votes. So let's hopefully play a little catch up here and we can move on. But I would urge a no vote. The vote is on the Cole Amendment. All those in favor say aye. Oh,
aye. Aye.
Ms. Fishbach?
Mr. Chair?
Yes.
Mr. Chair. Mr. Chair, I just wanted to voice my support also for the ranking member's amendment because, as a member of the Judiciary Committee, there's yet to be a single hearing or oversight or anything regarding the issue at the southern border, the crisis at the southern border. And I think that the resolutions of inquiry would be a place where this would be an important thing for the minority to use. And so I'd like I said, voice my support for the ranking member's amendment. Thank you.
All right. All right. Anyone else? Okay. Hearing nobody else, the vote is on the Cole Amendment. All those in favor say aye.
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 Opposed, no. No. Opposed, have it.
Mr. Chair, on that, I'd ask for a recorded vote.
A recorded vote has been requested. The clerk will call the roll.
Mrs. Torres?
No.
Mrs. Torres? No. Mr. Perlmutter?
No.
Mr. Perlmutter? No. Mr. Raskin?
No.
Mr. Raskin? No. Ms. Scanlon?
No.
Ms. Scanlon? No. Mr. Morelli?
Morelli is no.
Mr. Morelli? No. Mr. DeSaulnier?
No.
Mr. DeSaulnier? No. Ms. Ross?
No.
Ms. Ross? No. Mr. Cole?
Aye.
Mr. Cole? Aye. Mr. Burgess?
Aye.
Mr. Burgess? Aye. Mr. Rushenthaler?
Aye.
Mr. Rushenthaler? Aye. Mrs. Fishbach?
Aye.
Mrs. Fishbach? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments.
Mr. Chairman,
Mr. Cole.
Thank you very much, Mr. Chairman. Mr. Chairman, I would move that we have an open rule, that we don't have a particularly heavy legislative week. Frankly, one of these bills, certainly the one dealing with pregnant workers, is going to pass overwhelmingly. Not going to be a matter of great deal of partisan interaction there. And I think on the credit bill, actually, I think there is a bit of a missed opportunity here. Never quite got fully answered by the chair, but chair of the Financial Services Committee. But I think were quite a few elements in the Republican substitute, not the whole thing, that frankly there would be common ground on. And I just think we missed the opportunity in committee. We ought to take the opportunity on the floor to fix that. I think we can do it. I think in which case that's a bill that would pass overwhelmingly as well. So again, would just move that we have an open rule this week, given the light calendar that we have.
Yeah. Thank you very much. I mean, I just say, I think this is a fair rule. 14 amendments, including the substitute, has been made in order. I mean, we're still voting in a way that it takes about 30 minutes plus to vote. I mean, I actually think you had a better point on your previous amendment than you do on this amendment. But in any event, that's just me. So I would.
Well, that's disappointing because you didn't vote for my previous amendment, Mr. Chairman. So I just have such little hope now going into this exercise. When my friends were in the majority and we didn't have a pandemic in the last session they were in Congress, they didn't do any open rules. So I think we have a case to be made here that we're not quite at the point where we can do that. But again, one thing where we might agree, Mr. Chairman, I don't think we need 30-minute votes anymore. I mean, I hope you're serious, and I don't say this in any kind of critical way at all. I hope you're seriously considering that. I think we're at the point. I got the extraordinary news today in my apartment that the gym and the apartments now open up. If the gym and the apartments open up, we ought to be able to open up the floor of the Congress as well. So hope that we can move toward more regular order when you have the opportunity to do that.
And let me also acknowledge that Dr. Burgess sent me a letter, which I know he sent to the Speaker and others, talking about trying to move the date to get more back to normal. I think, we're waiting for an update from the Office of the Attending Physician. I think there's some additional guidance that's coming out today or tomorrow. So we will figure all of that out. But look, I mean, I think, I think everybody, I look forward to being in person with all of you in that room, in the Rules Committee room, as soon as humanly possible. So anyway, I think we'll see what guidance we get from the attending physician's office. But at this point, I would urge a no vote.
Mr. Chairman, if I could, I thank you for acknowledging the letter and that your receipt of it. But the attending physician is not a constitutional office. He does not have the power. It is the Speaker who has the power, and it's the Speaker who must exercise the power and bring back the people's house.
Right. Yeah, and I would just say in defense of the Speaker, she's a Speaker who actually believes in science, and so she is.
Unlike the attending physician, apparently.
She is listening. Well, she is listening to the guidance of our medical experts, the attending physician, the CDC, and others. So, I mean, that's the deal. But again, I think we're moving, and hopefully we will, get to the place where everybody's happy. And then when we're all together, you're all going to be wishing that we were not together. But in any event, putting that aside, again, the vote is on the Cole Amendment. All those in favor say aye.
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 Opposed, no. Chair, the noes have it.
Mr. Chair, on that, I would ask for a recorded vote.
Recorded vote has been requested. Clerk will call the roll.
Mrs. Torres.
Torres, no.
Mrs. Torres, no. Mr. Perlmutter.
Perlmutter's a no.
Mr. Perlmutter, no. Mr. Raskin.
No.
Mr. Raskin, no. Miss Scanlon.
No.
Miss Scanlon, no. Mr. Morelli.
Morelli is no.
Mr. Morelli, no. Mr. DeSaulnier.
No.
Mr. DeSaulnier, no. Miss Ross.
No.
Miss Ross, no. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Burgess.
Aye.
Mr. Burgess, aye. Mr. Reschenthaler,
Aye.
Mr. Reschenthaler, aye. Mrs. Fishbach,
Aye.
Mrs. Fishbach, aye. Mr. Chairman,
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments?
Mr. Chair, I have an amendment.
Ms. Fishbach.
Mr. Chair, I have an amendment to the rule to make in order amendment number 1 to HR 1065 offered by Dr. Fox of North Carolina. This substitute amendment ensures that religious organizations can make religiously based employment decisions. And Mr. Chair, as we discussed during the hearing, this bill is a significant departure from past practice as religious exemptions are typically included in these types of legislation. With so much bipartisan work and agreement, it's unfortunate the majority pressed forward with the departure from this precedent. For this, whether you agree with the changes the substitute amendment makes or not, it certainly deserves an opportunity for a floor vote, and I urge the adoption of my motion. Thank you.
You heard the gentlewoman's amendment. Any discussion? I will urge a no vote on what I'll call the shaker amendment. No other discussions. The vote is on the Fishbach amendment. All those in favor say aye.
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 Opposed, no. No. Chair, the noes have it.
Mr. Chair, I request a recorded vote, please.
A recorded vote has been requested. Clerk will call the roll.
Mrs. Torres,
No.
Mrs. Torres, no. Mr. Perlmutter,
No.
Mr. Perlmutter, no. Mr. Raskin,
No.
Mr. Raskin, no. Miss Scanlon,
No.
Miss Scanlon, no. Mr. Morelli,
Morelli's no.
Mr. Morelli, no. Mr. DeSaulnier,
No.
Mr. DeSaulnier, no. Miss Ross,
No.
Miss Ross, no. Mr. Cole,
Aye.
Mr. Cole, aye. Mr. Burgess,
Aye.
Mr. Burgess, aye. Mr. Reschenthaler,
Aye.
Mr. Reschenthaler, aye. Mrs. Fishbach,
Aye.
Mrs. Fishbach, aye. Mr. Chairman,
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Are there further amendments?
Mr. Chairman,
Who's that?
it's Raskin.
Oh, hey.
I just wanted to notify the committee I received an email from a constituent who said, please clarify there's a difference between Shakers and Quakers, and the Quakers do not oppose procreation or pregnancy. So I thought I would just put that on the record, Mr. Chairman.
Thank you very much for stating that. Okay, now all right, now the vote is on the motion from the gentleman from Colorado. All those in favor say aye. Aye.
Aye.
Opposed, no.
No.
Continue the chair, the ayes have it.
Mr. Chairman, on that, I would request a recorded vote.
Recorded vote has been requested. Clerk will call the roll.
Mrs. Torres,
Aye.
Mrs. Torres, aye. Mr. Perlmutter,
Aye.
Mr. Perlmutter, aye. Mr. Raskin,
Aye.
Mr. Raskin, aye. Miss Scanlon,
Aye.
Miss Scanlon, aye. Mr. Morelli,
Morelli is aye.
Mr. Morelli, aye. Mr. DeSaulnier,
Aye.
Mr. DeSaulnier, aye. Miss Ross,
Aye.
Miss Ross, aye. Mr. Cole,
No.
Mr. Cole, no. Mr. Burgess,
No.
Mr. Burgess, no. Mr. Reschenthaler,
No.
Mr. Reschenthaler, no. Mrs. Fishbach,
No.
Mrs. Fishbach, no. Mr. Chairman,
Aye.
Mr. Chairman, aye.
Clerk report the total.
8 yeas, 4 nays.
And the motion is agreed to. And Mr. Perlmutter will carry it for the majority.
And Mr. Reschenthaler will carry it for the Republicans.
Okay. Oh, can I ask the clerk, how was Mr. Perlmutter recorded?
Mr. Perlmutter was recorded as aye.
Yes, I'm an aye.
Okay.
Aye.
Yeah, I think we wanted to make sure you repeated your vote because you weren't, you're alive and technicolor on the screen. So we have rules here that we have to abide by. In any event, okay. So without objection, the committee is adjourned.